The Supreme Court just issued a 7-2 decision that every gun owner across America needs to understand immediately. One poorly chosen word when law enforcement inquires about firearms and your perfectly legal weapon becomes the basis for a felony prosecution. I'm revealing the exact statements district attorneys extract from police reports to construct cases against responsible gun owners who believe they were following all the rules. Today, you'll discover the 5 most destructive answers that dismantle your legal protection before you ever see a judge. By the conclusion, you'll understand the specific language that shields you and the statements that give prosecutors everything they require. Recently in Texas, a permitted carrier uttered merely 4 words during a standard traffic stop. Those 4 words stripped him of his carry license, generated more than $8,000 in attorney costs, and consumed 2 years battling criminal charges. He thought he was being helpful. He was entirely mistaken. Hit that subscribe button because this knowledge could prevent your financial destruction and defend your Second Amendment freedoms. Dangerous response number 1. Yeah, I've got a firearm. This appears forthcoming and truthful. Here's how prosecutors exploit that admission. When an officer inquires about weapons, your natural impulse is to respond directly. The difficulty? That statement legally confirms possession without demonstrating legality. It fails to reference your license, fails to specify placement, fails to establish lawful basis. Under the evidentiary principle of statement against interest, those terms transform into prosecution proof. You've affirmed the weapon belongs to you while supplying 0 facts regarding authorized possession. In Texas 2019, a concealed carry license answered, "Yeah, I've got one." When questioned about weapons, the officer promptly charged him under Texas Penal Code 411-172, failure to deliver proper notice. Texas statutes demand particular notification phrasing, not merely an affirmative response. Outcome: court dates exceeding $8,000 in legal expenses and half-year license revocation. His lawyer verified that correct phrasing would have averted the entire legal action. Here's your safeguard in notification required jurisdictions. Officer, I'm informing you that I possess a valid concealed carry license, period. This confirms your lawful standing and satisfies notification requirements. No expansion, no additions. Yet, most firearm owners assume offering additional details eases tension. The second answer demonstrates why that impulse annihilates your protection. Dangerous response number 2. It's stored in my glove compartment. Here's how prosecutors manipulate placement specifics. You're pulled over for a malfunctioning brake light. Officer asks about weapons and you aim to be open, so you disclose precisely where it's kept. You just confirmed knowing possession and ready availability, the 2 essential components prosecutors require for unlawful carry accusations. If that placement breaches any regulation or storage statute you didn't know existed, you delivered their complete case. In Florida 2022, a motorist informed an officer his pistol rested in the center console. The officer discovered it loaded in a locked container. The motorist held a valid license, but Florida Statute 790-025 requires particular storage standards. His voluntary disclosure became the prosecutor's proof demonstrating immediate accessibility without adherence. The accusation: improper concealed carry. The toll: over $6,500 and 19 months of judicial process. His lawyer indicated the matter likely would have been dropped had he refused to specify placement. Your defensive reply after notification when questioned about location: I'd rather discuss particular specifics with my legal representative. Present yourself and follow all safety directions, but don't volunteer placement information. The third answer sounds prudent but generates a verification hazard. Dangerous response number 3. My permit is current. Here's how prosecutors exploit verification. The problem isn't announcing you're licensed. The problem emerges when the officer verifies. Perhaps your permit lapsed and you neglected renewal. Perhaps your new residence state doesn't recognize it. Perhaps an administrative hold exists you weren't notified about. Now you've supplied inaccurate information to authorities. An independent criminal violation in 43 states. In Virginia 2023, a license holder told an officer, "My concealed carry permit is valid." During a speeding citation, the officer learned it had been suspended 4 months prior due to an outstanding fine. The driver never received suspension notification following his move. He possessed absolutely no knowledge his permit was inactive. Charges: carrying without valid authorization under Virginia Code 18-2-38, plus false statements to law enforcement. Total expense: over $9,000 in defense costs, 14 months of court dates, and a permanent criminal record appearing on every background screening. The phrasing that guards you: Officer, I'm a licensed carrier and I prefer to confirm my current authorization status through legal counsel before proceeding. If legitimate, your lawyer verifies it immediately. If any problem exists, your lawyer addresses it before you've made declarations prosecutors can cite. The fourth answer appears defensive but supplies prosecutors evidence of criminal purpose. Dangerous response number 4. I carry for personal safety. Here's how prosecutors exploit this justification. The officer asks your reason for carrying. You want to appear responsible, so you explain it's for personal safety. You just established intentional purpose to maintain that weapon accessible for protective application. If your carry circumstances are illegal for any cause, prohibited area, license complication, alternate jurisdiction, the prosecutor possesses your recorded declaration proving you intended it accessible for deployment. That elevates accusations from technical infractions to deliberate weapons violations with stiffer consequences. In California 2023, a CCW Lency was discovered armed within a posted weapon-free zone. When asked his reason for carrying, he stated, "For personal safety. There's criminal activity here and my permit is legal." The prosecutor employed that declaration to argue he intentionally disregarded posted limitations, prioritizing individual safety over statutory obedience. What might have been a misdemeanor escalated to felony prosecution under California Penal Code 26,230. The ordeal over $12,000 and 21 months until resolution. When questioned why you're armed, your sole secure reply, "I prefer to consult with counsel." Don't rationalize, elaborate, or defend. Your motivations remain between you and your lawyer, not roadside declarations. The fifth answer demolishes more protections than all others combined. Dangerous response number 5. I had no intention of using it. Here's how prosecutors exploit panic declarations. The officer locates your firearm and you want to reduce tension, so you say, "I wasn't planning to deploy it," or "It slipped my mind that it was in the vehicle." You just admitted to knowing possession while destroying any Fourth Amendment challenge regarding the search itself. When you state, "I had no intention of using it," you confirmed you knew the firearm was present. That eliminates arguments it was planted or you were ignorant. When you claim "It slipped my mind," you're confessing carelessness. In jurisdictions with storage laws, carelessness constitutes a separate criminal violation. When you insist "I never handled it," you are requesting forensic examination. When your fingerprints appear on it, you've made a demonstrably false declaration. That's an additional charge. In Georgia 2023, a motorist was stopped with a visible firearm on the back seat. When the officer noticed it, the owner exclaimed, "I'm not going to use that. It slipped my mind after the shooting range yesterday." The officer cited improper storage. The prosecutor employed his admission to prove knowing possession with failure to secure per Georgia Code 1611-126. What should have been a $150 ticket became a misdemeanor with a $1,500 penalty, compulsory safety instruction, and 18-month supervision. If an officer discovers your firearm, say nothing regarding it. Your sole declaration, "I'm invoking my right to remain silent, and I demand counsel present." Nothing you volunteer enhances your position. Everything constructs the prosecution's case. Rapid legal defense summary. Let's review the 5 answers that dismantle your protection when police inquire about your weapon. 1. Yeah, I've got a firearm. Confirms possession absent legal basis. 2. It's stored in my glove compartment. Proves knowing control prosecutors exploit. 3. My permit is current. Exposes you to false statement accusations if any issue arises. 4. I carry for personal safety. Provides prosecutors intent proof to escalate charges. 5. I had no intention of using it. Admits knowledge and annihilates every protection. Any individual answer can cost you thousands in expenses, your license, and your liberty. When police inquire about firearms, I'm invoking my right to remain silent and I demand counsel. When an officer asks about any weapon, provide notification only where statutorily mandated. Then exercise your right to silence. Now, I want your input. Have you been stopped and questioned about weapons? What did you state and how did the officer react? Share your experience below because your account could assist thousands of fellow gun owners. If this video provided legal knowledge that could rescue you from prosecution, strike that like button and subscribe. We're cultivating a community of educated firearm owners who understand their protections. Remain legally shielded and remember that silence represents your most powerful defense until your attorney stands with you.